We hear a lot about states' rights, particularly from the current administration. We are told that we should be leaving environmental regulations to the states, that they are in the best position to determine how to protect their environment and natural resources. We're also told that states, not the federal government, should have the primary jurisdiction over regulating the majority of our water bodies, and that the Clean Water Act should be restricted to just traditionally navigable waters. But not surprisingly, when states use the authority legally delegated to them under the Clean Water Act to protect water quality, we hear from those same people that those states have somehow abused their power and must be reined in. That is absurd, and it undermines the foundation principle of cooperative federalism enshrined in the Clean Water Act. It seems that some policymakers are willing to throw the baby out with the bathwater and restrict the rights of all states under the Clean Water Act simply because they disagree with the lawful decision of some states, including my own, to deny a very small number of permits. The Trump administration and the Administrator Wheeler have explicitly said that they are proposing changes to the Section 401 process because of New York's gas blockade. The administration has cited 3 high-profile denials by the state of water quality permits for interstate natural gas pipelines as an example of unnecessary delays. However, in each of those instances, the state's denial was based on relevant water quality standards and subject to judicial review. Additionally, New York State annually receives more than 4,000 applications for Section 401 water quality certifications and, on average, denies approximately 8. That means the state is approving more than 99% of the applications it receives every year on time. Hardly the picture of obstruction or an out-of-control state regulator. So what then is this really about? It is about removing a perceived roadblock to establishing a more industry-friendly regulatory process that gets meddlesome state regulators out of the way so that special interests can build what they want, where they want, even if it means harming water quality and running roughshod over principles of federalism they claim to support. This is bad policy, it is short-sighted, and could have very damaging impacts in our states. With that, Ms. Watson, I have a couple questions for you. Under the Section 401 process, states can apply conditions on federal permits and licenses to ensure that projects meet applicable state water quality requirements. However, the Trump administration's proposed rule would restrict the types of conditions that states can set and give federal permitting agencies the authority to veto them. Could you describe the types of conditions that states might impose on a project that would not otherwise be included on a federal permit? What impact will this have on wetlands, streams, and other water bodies impacted by the construction or operation of a project?
So there are a lot of examples of conditions that states might include in 401 certifications to protect water quality that wouldn't otherwise be covered by the federal permit. Examples of that would be protection of groundwater sedimentation standards, erosion standards, best management practices for stormwater, protections for endangered species. These are things that get added through the 401 certification process that have routinely been included in federal permits for the last 50 years without a problem. These are state-based water quality requirements, and what's being proposed through the bill and through EPA's rule would upend that 50-year states' control of water pollution in their states.
What are the practical implications of reducing the amount of time that states have to make Section 401 decisions? Will this result in more project approvals or improve water quality protection?
It will not result in more water quality approvals. It will actually have the unintended consequence of resulting in more denials because states will not have sufficient time to make decisions. But on top of that, EPA is limiting the amount of information that states can consider, and so states won't have the tools and the information necessary to be able to, in fact, protect water quality within their states.
Thank you. And I just wanted to respond to something our other witnesses said. Governor Gordon, I recognize that you want to be able to have the best economy for Wyoming, but the truth is, if you try to remove New York's regulatory authority, you will affect our economy, because our economy is based on clean air and clean water. We have agriculture all across New York that relies on clean air and clean water. We have a tourism industry that is very valuable. We have New York City, which is 8 million people, that gets clean water from a watershed, unfiltered water. if we had to filter that water, it would cost us tens of billions of dollars. So I just want to be clear. We know how to protect our state and our economy, and I would just suggest that you would give deference to our governor in the way that our governor would give deference to you in understanding what's best for your economy. And then Governor Stitt, I just was offended by your statements that you know how to have good water in Oklahoma, and I would just like unanimous consent to submit 4 articles from the record of how challenged your water quality actually is in Oklahoma, which I'm sure you were aware. And I'm grateful that you have made progress in eliminating some contaminants, and that's a good thing, but it may be because you're starting from a worse off place. Thank you, Mr. Chairman.